You're watching FJTN, the Federal Judicial Television Network. Coming up on Court to Court.
In our experience in Little Rock, in the Jones versus Clinton case,
we're all resistant to change. And this is a significant institutional change. It's a cultural change.
Communication is the most important aspect of a capital case with an execution set.
This is Court to Court, your connection to what's happening in the federal courts around the country, providing information and ideas that will enhance your job and how the courts function. Now with today's program, Michael Burney.
Welcome to Court to Court. This is the third edition of this educational magazine program from the Federal Judicial Center. On today's program, we'll learn how several courts managed some high-profile cases, hear lawyers' reactions to electronic case filing, understand what two legal terms really mean, get an update on managing capital cases, and we'll hear from your court colleagues. When it comes to scrutiny of our government, more often than not, public attention is focused on the executive and legislative branches. Occasionally, though, when a case of great notoriety reaches the courts, that intense spotlight is turned on the judiciary, most often on an individual court, and sometimes it's quite unexpected. Regardless of a court's location, type, or size, the message of our first segment is anticipate and prepare.
Justice Department investigators believe they have enough evidence against Theodore Kaczynski, so much so they've begun to think about where to hold a trial.
I was very shocked to see vans and trucks and hundreds of people out there, and I'm going, oh my goodness, this is going to be really different.
We thought that there would be a significant amount of local coverage. We were unprepared, I think, for the amount of national coverage that we received.
Many courts discount the likelihood of ever seeing a high-profile case.
Well, earlier this morning I said...
But Clerk of Court for the District of Colorado, Jim Manspeaker, who managed the Oklahoma City bombing trial, knows better.
In the back of your mind, you should know that very possibly you would get a large, high-profile case at some time. So the normal organization of your court that carries you day to day may need to be enhanced.
Chief Judge Susan Weber Wright stresses the legal implication in these situations.
The most challenging aspect of dealing with a high-profile case is preserving the right to a fair trial that the parties enjoy under the Constitution.
The proportions of everything increase in these cases. When the sitting governor of Arizona was tried on several fraud and extortion charges, Clerk of the District Court, Richard Weir, involved all the trial stakeholders from the start.
We met early, we met often as we needed to every time there was an issue that came up. We tried to anticipate every question, every circumstance, every situation that might come up so that we would have a contingency plan in place that we could use.
At a recent 8th Circuit Clerks Conference, Jim McCormick, clerk of the District Court for the Eastern District of Arkansas, described the impact of Paula Jones' civil suit against President Clinton. The court simultaneously dealt with several high-profile criminal cases.
I was amazed at the number of people we had to bring in, and we started having regular weekly meetings with people who really had a say. Because I could take them to the front door. I controlled my space, my records, but out the front door, it was a security issue with the Marshal and the Federal Protective Service, but once you got beyond the curb, all of a sudden you had to get the city involved. We had the mayor, we had the city manager, the director of public works, the Little Rock Fire Department, the public relations coordinator, Southwestern Bell, the ambulance service, the Federal Protective Service, GSA, the Little Rock Police Department. We had the media consortium.
Dealing with the media as one group rather than as separate entities is a must.
Well, the strategy with the media was interesting because we'd never done it at that magnitude before. I set up a meeting with the media early on. We surprised him a little by having Judge Mach there and introduced him. There were no questions taken or anything. He made a very brief statement and then left. I then gave certain ground rules to the media.
In our experience in Little Rock, in the Jones versus Clinton case, we found that if we gave the media equal access to the information and made that information available to all media outlets in as quick a way as possible and as wide a way as possible, that we could in fact satisfy the media's demands and we could continue with our court business. However, it did take quite a few adjustments before we got there.
These clerks of court agree it's a good idea for court colleagues to share information, especially when dealing with news organizations.
Everything they'd come to my office with, they said, well, this is what Man Speaker did for us in Denver. Most of it wasn't true, and they embellished quite a bit, which was a really good reason to keep an open line to Jim.
Legitimatizing the media was very interesting. They had to give us an application form. And then the Federal Protective Service ran a background check on all 2,300 applicants. We cleared up a number of traffic tickets around the country.
Courtroom seating is a huge issue. The Denver court designated half its seats, 54, for news organizations.
And during all the pre-hearings, pre-trial hearings and things like that, we determined who were really interested and who, if they came every day, they then went to the top of the list. So by the time we got to trial, we had 48 media organizations that we gave the seats to and would draw 6 every day. The media outside, that's where the big crunch was.
Jim McCormick knows a thing or two about media outside the courthouse.
We had private vendors getting in and requesting barricade permits. And they would build risers, which are kind of bleachers for cameras. And then they were renting out 8-foot sections of these risers to different members of the electronic media for $40,000 a section. Who anticipated that? It was just amazing how complicated it got.
Sacramento also assigned half the courtroom seats to the media, and everyone had to have a pass.
The passes to get in the courtroom were color-coded. And if you were on the prosecution team, you had a particular color. If you were on the defense team, you had another color. If you were a family member of a victim, you had a distinct color. The press had a color, and the public had a color. And if you didn't have a pass, you didn't get in the courtroom.
With space at a premium, Richard Weir piped closed-circuit television into an adjacent courtroom.
We found that more of the press ended up using the overflow courtroom than the actual trial courtroom because they could write, they could work while they were observing what was going on.
Phoenix also set up a specific room for the media.
We didn't find it to have severe budgetary ramifications for the court because we set up a media room, but the media paid for that room. They paid for the telephone lines coming in, they paid for the equipment that they wanted to use in the room.
Another problem to solve was that so many people wanted documents.
We used the internet on a daily basis by, we scanned every document that was filed in the case and it was put over the internet. We had a copy service we contracted with. They came over and picked up every document and within 30 minutes had that printed and available for purchase if you wanted to purchase a document. The court reporter used an internet agency for copies of the transcripts on a daily basis, so they had that available. Everything that anybody wanted to know was available immediately.
The unexpected ordeal of managing a big trial now behind them, the advice of this court staff and judge is be prepared.
Coordinate early on with the marshal's service and the media and other judges. Arrange for some regularity about the way media is handled so they will know what to expect and when to expect it.
I think we built on the models that were out there. We shared information, and it was an incredible effort.
It's the day-to-day tasks, the logistics of just managing the number of people that we had to deal with.
I think the greatest lesson is that the system works, and it works very, very well.
So you can see there's a network of court colleagues ready and willing to assist you if you're confronted with a high-profile case. Another excellent resource is this book, A Manual for Managing Notorious Cases, published by the National Center for State Courts. On a different topic, the Center is making available a 40-hour self-study course for supervisors. Foundations of Management was originally developed by the National Independent Study Center. Case scenarios and exercises have been adapted to reflect the work of federal court supervisors and managers. For more information, please call 202-502-4122. A separate course is available for probation and pretrial services managers. To request that version, call 202-502-4114. On our first Court-to-Court program, we brought you information about how 2 courts are making the transition to electronic case filing. One response to that segment, which we reported on in our second program, suggested that we look at how ECF affects the bar. Today, we'll see that involving the bar is one key to making the transition to ECF.
Felix Garcia is a New York attorney who handles many bankruptcy cases. He was wary of electronic case filing at first.
I was a little worried about this new type of filing because it was not familiar to me.
We're all humans, and we're all resistant to change. And this is a significant institutional change. It's a cultural change.
In 1996, the District Court for the Northern District of Ohio mandated that all pleadings in the specialized maritime asbestos litigation be filed electronically. Through the Internet, the court has received more than 165,000 pleadings for 16,000 cases.
I would say that the greatest impediment to the bar's utilization of electronic case filing is their lack of familiarity and understanding of the system.
Because of not knowing how to, not knowing much about this new type of filing, I did hesitate.
Garcia overcame his hesitation with the help of the staff of the Southern District of New York Bankruptcy Court.
When the Chapter 7 filers came along and realized that they actually were saving the money, either time or money, by doing it in their firms, they became avid fans of the system.
It gives me flexibility. I'm able to file these petitions at any time. I don't have to commit myself to filing during business hours or during the hours that the court is open.
Garcia's use has grown dramatically.
I'd say about 50% of my Chapter 7 petitions through the electronic case filing system.
Larger firms working with Morris's clerk's office are also enthusiastic.
We saw that as an opportunity to move forward on something that we perceived, and I think correctly, would be the wave of the future.
But the future means a cultural change. And increased speed and convenience only goes so far in getting the bar to use ECF.
We can encourage and, if necessary, cajole the attorneys into agreeing to put the case into electronic filing. However, it ultimately has to depend to a great extent on the willingness of the attorneys to go along with it.
And how does one get attorneys to go along with it?
I came to trust the system simply through using it over the course of several months and just putting it through its paces, filing different documents, seeing if it worked.
I think that the encouragement from the court, particularly the judges, is probably the most significant factor in getting attorneys and firms comfortable with using the new electronic filing system.
We involved the bar from the very beginning in the electronic case filing project. We set up a committee of attorneys to help us draft rules and to draft procedures for electronic case filing. And I think that went a long way toward making the bar feel that the rules that we had come up with were practical rules.
I think the Rules Committee was very successful. Some of the key issues that were discussed were issues such as the security of the system and the ease of use for attorneys, whether attorneys would be able to file documents that would be signed, basically how attorneys would satisfy Rule 11 requirements.
Getting members of the bar to agree to ECF is one thing. Getting them to use it is another.
Any project that actually changes the way someone comes to you uses a system. It takes a lot of time and effort in training.
We got terrific training from the court. The on-the-ground training in the law firm is probably the most important because it gets the attorneys comfortable with the system. Younger attorneys are automatically comfortable with the system because they grow up utilizing computers.
Good morning. My name is Evelyn Rodriguez, and this is my colleague Daryl McFadden, and we'd like to welcome you to the Bankruptcy Court and familiarize you with the electronic case filing system.
I think that maybe extra time needs to be spent with those of us who have practiced longer and are more used to the paper society and are frightened by pressing a button on a computer to affect a legal consequence.
Now I'd like to turn over the presentation.
Overcoming those fears often means one-on-one attention, which can become a resource issue for a court.
Currently, the way things work in the intake office, and as they have for years in the courts, are that the attorneys come into court, into the clerk's office, and this ECF training reverses that, and we actually go out to the attorneys to train them on their machines. With electronic case filing, the attorneys are using their computers, and therefore it was our conclusion that that's what we need to train them on, is their computers.
That hands-on attention, though, is really important. That's very difficult to give. It's very labor-intensive for the court.
It does take more time. It takes more time, and it definite more strain on the clerk's office having an employee out doing this.
The payoff is in the reduction in the amount of paper, the reduction in the phone calls we get, in needing documents immediately. And we hope within this year the reduction in even the technical needs that they experience will be diminished.
Right now in my firm's Cleveland office, I would say that approximately 10% of the litigators are involved in cases in the electronic filing system, and I expect that that number will probably increase to well over 70% of the litigators in the next 5 years.
So it's a matter of never being discouraged, always marketing it, whether it's internally or with the bar, and getting out there, just getting out there and sitting down with folks one-on-one or in a group environment to demonstrate the system and make ourselves available whenever and however we can.
Still ahead on Court to Court, we'll hear about dealing with death penalty execution cases, learn what jurisdiction and habeas really mean, and find out what you say about the program. Now watch this.
I'm an evaluation form. You've surely seen me before. Well, I'm part of your materials and I perform a vital chore. Well, the information in me helps the center to take stock. It helps them make their programs work to help you do your job. Please fill me in. Please fill me in. Oh, we need this information. Please fill me in. Please fill me in. Oh, we need to know the score. Please fill me in. Please fill me in. Your feedback is important, and if you don't complete this form, we'll sing this song again.
Your feedback is important. Please fill in the evaluation form available in your program materials or online on the JNet.
Be sure to watch Perspectives, the magazine program for probation and pretrial services personnel. We bring you news on national issues affecting the system, as well as reports and interviews from the field. On-location stories highlight innovative practices in districts large and small. You'll get the legal perspective from the AO's David Adair and the latest updates from the Sentencing Commission. Join us for Perspectives on FJTN. Check the FJTN Bulletin or the JNet for dates and times.
We've received many requests to help understand two words that are used every day in the courts: jurisdiction and habeas. Here with these words to know is my colleague, Bob Fagan.
How many times have you heard the phrase, "Do we have jurisdiction in this case?" Do you ever wonder what jurisdiction really means? Jurisdiction is simply the authority or power of a court to hear and decide a case. To better understand this concept, let's talk first about the differences between state and federal jurisdiction. State courts are considered courts of general jurisdiction. Their authority extends to civil disputes, criminal prosecutions, divorce and family issues, and probate. Federal courts are courts of limited jurisdiction. Their authority to decide a case arises from a specific federal statute or from a provision of the U.S. Constitution. Most cases come into the federal courts because they involve disputes between citizens of different states or because they involve violation of federal law. But wait, there's more. In both state and federal courts, jurisdiction is also divided into original and appellate. Original jurisdiction means a court has the power to hear a case for the first time. Trials are held in courts with original jurisdiction. These would be the lower courts in the federal system. Appellate jurisdiction refers to the power of an appeals court to review decisions of lower courts and either let stand those decisions or overturn them. In the federal system, the appellate courts are the 13 circuit courts of appeal and the Supreme Court. The important point to remember is that any court may decide a case only when it has the authority or the jurisdiction to do so. Now let's consider habeas. You'll most often hear this term used in the phrase, a writ of habeas corpus, which sometimes is shortened to simply habeas. Habeas corpus is Latin, meaning to have the body. A petition for a writ of habeas corpus is filed in court with the intent to obtain the release of someone wrongfully imprisoned. Habeas proceedings allege that a conviction violates the defendant's constitutional or statutory rights, or that the sentence imposed violates those rights. A petition for a writ of habeas corpus is filed in a case only after all trials are concluded and all appeals denied. The court in which the petition is filed must then decide whether there's been a violation of the defendant's rights. If the petition is denied, the defendant can file it in the next higher court, including ultimately the U.S. Supreme Court. The most dramatic use of habeas is in death penalty cases. Congress recently has placed stringent restrictions on when and how frequently someone may use habeas petitions. We'll hear more about this in our next segment. And we'll be back in our next program with more Words to Know.
As Bob said, Congress has enacted legislation that affects habeas corpus petitions. The Anti-Terrorism and Effective Death Penalty Law limits defendants to filing only one federal habeas petition, except in unusual circumstances. And it must be filed within 1 year of the date judgment becomes final. As the frequency of death penalty case executions increases, the likelihood that a court will handle last-minute filings also increases. The courts are dealing with people's lives, and we all want to ensure that requests by the petitioners are processed as quickly as possible. We covered a recent presentation to appellate clerks and chief deputies by Cynthia Rapp, staff attorney at the U.S. Supreme Court, who manages all death penalty filings at the court.
As far as determining which cases are emergencies and not, you have in front of you a 2-page death list. This is something that I do every week. It comes out every Monday. It normally will list the upcoming executions for the next month.
The number of death penalty case executions is rising. Last year there were 68 executions. Through the middle of May this year, there have been 44.
This year, 1999, will probably go over 100. And I think that means that a lot of courts that may not have seen executions are going to see them. So if they don't have procedures in place now, they need to put them in place.
The Anti-Terrorism and Effective Death Penalty Law, often referred to as ADEPA, means district and appellate courts need a way to track the 1-year limit on filing habeas petitions.
Because the statute it's not jurisdictional, it's been deemed to be equitable. So there are maybe an instance where the 1 year has actually expired, but the petition would still be accepted because there was some type of equitable tolling. Perhaps the person didn't have an attorney, or there may be other factors involved.
The law affects successive petitions, too.
Because what people may do is they will come to the U.S. District Court with their habeas petition and attempt to file it. And it may be a successive petition, but they may not tell the district court that it is. So the district court needs to have a tracking system where they can look up to see whether or not this person has ever filed a habeas petition before.
Under the ADEPA law, defendants must request permission from an appellate court to file a successive habeas petition.
So the appellate court is going to get a request for authorization to file a successive petition without having any decision from the district court below. So they're going to be seeing these in the first instance.
For all court staff, the keys to managing death penalty cases are communication and a plan of action.
If you have a routine down, you're better apt to be able to handle it in a professional manner than kind of losing your cool because you don't know who to call and you don't know how to get information. If you deal with the same person over and over again and you have a good rapport, which I do with most all of the circuit courts, it's very easy to get information.
We are in constant communication with the district courts as well as the state courts in the state of execution in the 2 to 3 weeks prior to the execution date so that all of the courts know what is going on. And we in turn call the Supreme Court and let them know that potentially they're going to be involved.
The biggest thing up front would be to make sure your judges are aware of when there are upcoming executions. You want to make sure you know how to get in touch with your judge or judges because they're going to be required sometimes to vote at the last moment.
During the seminar, Rapp described trying to reach justices in the evening.
The justices normally are not in the building, which causes a problem, obviously, as you are aware of trying to track them all down and get them to vote. They tend not to want to carry cell phones or beepers with them or not be disturbed. It can be understandable now, given the volume of cases, we're getting 10 a month.
Shoemaker's advice for court staff?
Find out who is handling the case in district court. Communicate with your judges about important information. Communicate with your own staff so that they're kept up to date.
I got some more info for you on the new death penalty procedures.
Most courts designate one person to deal with death penalty cases.
I think whoever it is needs to be someone who does it all the time so that that person does become familiar with the other people that they'll deal with and has procedures down.
And Shoemaker says, have a backup plan.
Even if something came up that I was not in the office or the clerk wasn't in the office, other people would be made aware of the situation so nothing would fall through the cracks.
Another issue is compliance with rules.
Are you in the clerk's office going to say, I'm sorry, this does not comply with our rules, please redo this and resubmit it? I don't think so. But, the hour before the execution, I am not going to be the one to not accept something. If the justices don't want it, fine, they can tell me that, but not me.
Our court does not allow filing by fax, except in death penalty cases. When we get down to the wire with an execution set, we let counsel file faxes, and in fact, we spend a lot of time standing at fax machines waiting for papers to come.
Ethics are another aspect of dealing with these cases.
How much do you tell the other side? It's to our benefit if both sides know what's going on, because then we can get things in quicker, and that usually is what our goal is to get all the papers in, get them all to our judges so that they can make their decisions. And that's a fine line. What do you tell them? If the state calls you and says, have you heard anything? Do you know what's going on? I normally won't tell them. I may say, I've talked to them and I think they're going to file something. I won't obviously tell them what the issues are at that point. The defense attorney's afraid, well, I'm going to tell her that this is what I'm doing, and she's just going to go ahead and tell the state AG. Well, I won't. And especially if they've told me not to, I will not.
As so frequently is the case, court colleagues are one of the best sources of help.
So I would suggest getting in touch with a circuit or a U.S. District Court that already is doing this and find out what it is that they're doing, what's working, what's not, before you try to reinvent the wheel.
Rapp also advises court staff to plan for the emotions of handling these cases.
They need to keep in mind it is something that is stressful, and I think what's helped me a lot is being able to talk about it with other people in the other courts who do this all the time, because sometimes it does become so routine, and then all of a sudden you think about what it is that you're working on, and you realize it shouldn't be routine, and I think you need to be able to voice those things to people who understand.
On April 12th, Chief Justice William Rehnquist announced that the Federal Judicial Center's board selected District Judge Fern Smith of San Francisco as the new director of the Federal Judicial Center. Judge Smith succeeds Judge Rhea Zobel, who in July will return to the U.S. District Court in Massachusetts after 4 years as director. Since 1996, Judge Smith has served as chair of the Judicial Conference Advisory Committee on the Rules of Evidence. She has been a district judge in California since 1988 and has written and spoken extensively on evidentiary matters, trial practice, and other topics. And now, it's your turn.
This is the part of the program in which we ask for your views and thoughts. Since our last program, we heard from Kathy Gould-Fellman, Chief Deputy Clerk in the Bankruptcy Court of the Southern District of Florida. She writes, "After watching Court to Court, many of our staff told me they really benefited from seeing the different situations facing other courts and how they handle them. They like seeing real deputy clerks and how they interact. This program helps us understand that all court units face the same issues and we can learn from each other." We're glad to know we facilitate that exchange of information, Kathy. It's a point which Patrick Fisher, clerk of the 10th Circuit Court of Appeals in Denver, also made about Court to Court.
It is the best replacement yet that I've seen for travel-based learning because you hear, the advantage of travel-based is not being there. It's being in the hallway, it's being at lunch, it's being at dinner, talking to people from other courts about how they do things. And hearing what other people have to say in a quick segment, it is enlightening. I mean, you get ideas from people that way.
On our previous program's evaluation forms, several of your colleagues commented that they'd like to have more information in each segment. Typical was Kathleen Johnson's comment from the District of Utah. She said, "The information given was too general. Maybe too many topics were covered in the short time frame. Possibly cover one area in more depth." As you may have noticed in today's program, we've responded to these concerns and have included fewer but longer segments. Your reaction and evaluation of what we've covered and how we're doing it will help us bring you the information you want. Finally, we received this comment from Chief Judge Paul Mattia of the District Court of the Northern District of Ohio.
One of the things that some of the staff have indicated is that it really helps them feel as though they are part of the important team because by providing training to them in this fashion, it indicates to them that we value their services and that we want them to improve their techniques.
Thank you to everyone who's commented about Court to Court. We want to hear from you because we want you to have a voice in this program.
Here's the JNet address you can use to send us your comments. Click on Court to Court and then select Online Evaluation. We encourage you to give us an evaluation of today's program, which you can do online, or you can fill out an evaluation at your site and mail or fax it to us. Our fax number is 202-502-4088. Be sure to check the FJTN Bulletin or the FJC website for the air date of the next edition of Perspectives on Probation and Pretrial Services. And we'll be back in October with a look at putting strategic planning to work in your court unit. That's Court to Court for today. On behalf of our staff here at the Federal Judicial Center, I'm Michael Burney. Thank you for watching.